joined by Brad Sherman, a colleague from California. Mr. Sherman, you may take as much time as you so find appropriate.
First, I want to thank the chairman for letting me participate. I'm not a member of the subcommittee. It may have already been introduced in the record, but if not, I'd like unanimous consent to introduce in this record a letter to Secretary Clinton signed by David Phillips, the Brigadier General, Wesley Martin, the retired colonel, and Leo Mikulski, the lieutenant colonel, retired, all in reference to this matter and dated April 19th.
Without objection, so ordered, and let me remind my colleague that this hearing will be over after the testimony and the questions and answers. We'll have a second round. Mr. Carnahan should have a chance to, hopefully, to ask his questions after these questions, and immediately after this hearing is adjourned, General David Phillips, who you just quoted in the letter, will be briefing us in this spot for those who would be interested. And you may proceed.
Hearing followed by a briefing. Who says Congress isn't fun? We had on May 8th the U.S. Court of Appeals dealing with the writ of mandamus on the MEK. First of all, Ambassador, are you aware of any other circumstance where a district court has issued a writ of mandamus on an issue of foreign policy directed at the State Department? Is this as extraordinary as an action as the courts have ever taken on a foreign policy matter?
My experience in this and those sort of legal proceedings is limited. I do gather that it is somewhat unusual.
Somewhere between highly unusual and utterly unprecedented would be the way I would characterize it. Now, during that proceeding, the lawyer for the State Department said the MEK did not permit an inspection. They did not permit a door-to-door inspection looking for caches of weapons or to actually disarm door-to-door. Since then, a letter has been signed by the soldiers actually involved in that searching effort, the Brigadier General, the Colonel, and the Lieutenant Colonel, all basically saying that the State Department lawyer lied to the court. Has the State Department taken action to make sure that the court has been advised that this lawyer that had no direct knowledge of the of what actually happened on the ground at Camp Ashraf said some statements to the court that might mislead the court as to the actual events?
Sir, this is a matter under active litigation, and so I have to be very careful. I said earlier, in response to a similar question, that it is my understanding that the Department of Justice has sent a letter to the court answering some of the questions. I believe that that letter has been filed and is available, but because it is active litigation, I have to restrain myself and not go any further.
Do you disagree with the three officers involved that, in fact, a proper door-to-door search for weapons was, in fact, conducted at Camp Ashraf?
Here, too, I believe that the letter from the Department of Justice addresses these issues, and because, sir, I'm in an awkward position. This is active litigation. It's taking place in federal court, and so my mandate is to try to get people safely out of Camp Ashraf, over to Camp Huria, and out of Iraq. That's my job, and I hope that the Department of Justice letter can clear all that up.
So your ultimate goal is to get them out of Iraq. Is that relocation facilitated by the designation of the MEK as a foreign terrorist organization? Or is it impeded by that designation?
The Secretary of State's decision on the designation will be made on the basis of the facts and the law, not on even my own
Yeah,
consideration.
and I didn't ask you what she's going to do or what she should do. I just asked whether the current situation impedes you and your stated goal. I mean, there may be other reasons why that designation is maintained, but as long as it's maintained, does it impede you in achieving your goal?
I have to work with the designation as long as it exists,
We know that.
and I will do my best to work with what I've got. That decision will be made apart from my office. Secretary Clinton did say on February 29th that MEK cooperation in the closure of Camp Ashraf will be a key factor in any decision. And it's also my understanding that the State Department is prepared to make that decision within 60 days of the closure of Camp Ashraf.
Is there anything in the statute that says you have to cooperate in moving into what could very well be an Iraqi government plan for a death camp in order not to be designated a terrorist organization? I've read the statute, and there's no I mean, there are lots of organizations around the world that are not cooperating in their relocation, and that is not a factor, under the statute at least, in designating an organization a foreign terrorist organization. My wife wants me to move, or us to move. I don't want to move. I'm not willing to move. Have you designated me yet?
Right. I wouldn't think of interfering in your wife's designation in any way.
But the point I'm making is there any legal basis to in effect, require relocation in order to not be designated or continue to be designated a terrorist organization?
Here, too, the question you raised is very close to the issues that are now being litigated, so I've got to stand back. Not actually my nature to do so, but it is it is required of me that I stand back because this is active litigation.
Well, it's active litigation as to which the court was misled by the State Department's attorney. It's active litigation as to which the State Department appears to be using designation as terrorist organization in order to push for policy changes that have nothing to do with whether one is a terrorist organization or not. You won't admit it on the record, but you certainly haven't argued against my belief that the fact that the MEK is designated impairs your efforts to get people relocated outside of Iraq. And if you have an argument against that conclusion, I'll give you a chance to, and I don't see you grabbing the microphone, so I'll go on, unless you do want to grab the microphone.
I won't argue against that assertion, but I will say that the efforts of all those who want to see the residents of Ashraf safe and secure and out of Iraq, that effort will be enhanced and advanced if we work together to help the process move along as it has moved along since December. The last convoys need to leave Camp Ashraf for Camp Huria. Camp Ashraf should be closed. The international community needs to step up and do its part to help people get out. And since I think it is important that all those who agree that this should be the objective ought to be working together to achieve that objective, and that's it's my hope that we can work together in that direction.
The chairman's been very generous, and I'll just conclude by saying it's by no means clear that this relocation is not an Iraqi government first step toward mass executions. But in any case, what is clear is that many of the countries in the world to which people may be relocated are democracies, and let me tell you, it would be extremely difficult for the immigration minister of any democracy to admit any person from this camp while the organization is designated by the great United States as a foreign terrorist organization. So if you're able to relocate anybody while that designation remains in place, you are doing the near impossible. But I'm not sure you can do the near impossible thousands of times, and we've got thousands of people to relocate. Mr. Chairman, thank you for this indulgence.
Yes, Mr. Sherman. We have with us Congressman Rivera, a member of this subcommittee, and he is recognized for what time he may choose to consume.
Thank you, Mr. Chairman. Ambassador, thank you very much for being here today. I'm wondering if you could apprise the committee on two issues. One is inspections, particularly State Department inspections, the status or history or evolution of State Department inspections. And second, this issue of the belongings, the personal belongings of those in Camp Ashraf, and as well as these reports of confiscations and lootings and so forth. So let's start off with the inspections.
I have, as I've said earlier, before you came in, sir, that because there is active litigation going on about Camp Ashraf and about some of these issues, I have to be extraordinarily careful. The mandate of my office is to help move people in safety and security from Ashraf to Camp Liberty, now called Camp Huria, and from Camp Huria out of Iraq. The issue of Camp Ashraf and inspections and all of that business is the subject of letters and motions. There is a long history to that. It's partly during the many years we had troops in Iraq, it was the Department of Defense that was responsible. The State Department, during my time responsible for this issue, has devoted its energies to working on the priorities I mentioned, that is the convoys from Ashraf to Huria, and the living conditions at Huria, and support of the UN mission, which is to help get these people out of Iraq. So the issue is being handled. The issue of inspections is being handled in another venue. I regret any expenditure of energy which will not advance the process I laid out. Our priority, it seems to me, should be to get people from Ashraf to Liberty and from Liberty out of Iraq, and to do so as quickly as we can, safely, and with consideration for basic, decent human standards.
Are you saying because of this ongoing litigation or these litigation concerns, you can't even comment or apprise the committee as to the facts, just in what has happened? I imagine it's not a secret what's happened in the past. What has gone on with inspections?
It is because this is. I mentioned a Department of Justice letter in the past couple of days, which has been filed with the court, which I believe answers some of these questions. I find it frustrating that a perfectly normal question, which is what you've asked, is because it is the subject of, because the topic is being litigated right now, is more difficult for me to answer than I would like. But that's the odd position we're in, and I will say again, I regret the diversion of energy into an issue which does not advance the cause of my office and my department, which is helping people out of Iraq in safety and security.
And the letter that you recently said, is that not a letter?
It's a Department of Justice letter, and it is part of the court filing, but I believe
Is that not public record?
I mention it because I understand it has been filed with the court and therefore is the public record, yes.
Do you want to apprise the committee of the contents of that letter?
Well, that's because it is a Department of Justice letter. Let me just refer, to it's available. I have to be very careful where matters of open litigation in the court are concerned.